Hi, today is the 21st of March. I'll be talking the 7th law video and I will cover tort law today. So you can see here like the Highland Towers in Malaysia collapse. So who is going to be responsible for this? So it falls under tort law. So this are what I'll be talking about. I'll be talking about what are the kind of features, what is duty of care, what is pure economic loss, breach and causation. One case study is accountants and auditors, remedies and damages, and conclude. So um, first, if you have a contract between the parties, then tort law must be consistent with the terms, right? But the terms must also comply with the law, because in the law we got rules on unfair terms. Later I will go through that. And they can also be liable to third parties outside from the contract. For there to be a tort, there must be a duty of care, there must be a breach of duty, and there must be remoteness and causation. Okay, so there are many types of tort. You have trespass to, like when you hit somebody, when you hit damage somebody's property, when you damage their reputation, when you are an occupier, and when you deceit, okay, fraud, and when you create nuisance, like if you live in a condo and your neighbor is playing the music very loud at night, like public nuisance. So many types of tort. Those tort, they sometimes they say it's like a rojak. Anything that is not contract, it's not criminal, they put inside tort. Okay. So there are many uncertainties because it's a new area of law compared with contract. Of course they will say the history is thousands of years, but lately it only developed in maybe 100 200 years only in UK. And judges sometimes they don't get it right. They always keep changing the rules. And you are trying to use old thoughts to solve modern problems. Like today, last time we got trespass to person, where somebody go and hit somebody. That was 200 years ago, very common. But today we have like doctors, medical negligence, right? So the modern problems, we have to create new solutions. Okay, sometimes we cannot use the old solutions to solve modern problems. So we go through the first requirement. We must have a duty of care. Duty of care, even though you are negligent, you breach your duty, but sometimes they say there's no duty. So the latest test is Caparo. Yeah, because I'm looking in terms of misstatements, negligent, what you say, because I cannot go through all the kind of thoughts. So today I will talk about what you say your wording, your words and what professional do. So the test is Caparo in 1990. You need to foresee the harm. If he knows that kind of harm will happen and he's proximate enough. So it's proximate means you are in a close relationship. Some say you are in a special relationship, and there must be fair, just, and reasonable to impose. So there are many types of consideration. Sometimes the court say because in UK most people are covered by insurance for tort cases. So whenever you get sued for tort, insurance will cover. So we don't really consider what is just anymore okay. Sometimes they consider what is public policy also. Later when you study more, you will see how the judges reason whether there's a duty or not okay. Like yeah, there are many. I cannot go through so much in detail, so I just skim through it. Normally you take about 9-10 hours to study all this, but I'll just do it like 30-40 minutes. So the Caparo test, but now the Caparo test, they say it only applies to new cases. Okay, if there are precedents, like whether an auditor owes a shareholder a duty, you follow the previous precedent. You don't have to go through the reasoning and go to court and find out whether a duty exists or not. You look at the previous cases. But even if you cannot find a previous case, it doesn't mean that they'll deny you. It's just that they want to make sure the law develops coherently, consistently with each other. Right. So in general, personal injury, property damage can claim, right? But the difficult part, where they say the complicated part, is pure economic loss. Pure economic loss is, you will see later why is pure economic loss. But why the court, normally the general rule why do they have this general rule is because they say they want to prevent floodgates. Too many people will sue. But you see, why you protect property but not financial, your money, your bank account. Your bank account is also considered an asset, right? It also can be say a type of property nowadays. Last time, of course, they got no banks 200 years ago, but see now. And so even if you have a defective product, like people die of cancer, right? You have smoking, cigarette companies, let's say you got drug companies and you got thousands of victims, right? Nobody say this is a floodgate, open the floodgate. This is but economic loss, normally only one guy will sue. So why is there a floodgates argument? So this argument maybe is not correct also. Yeah, you can read more on this. And but the main reason is because they find that you cannot if you allow pure economic loss, the companies or the defendants cannot predict their liability. Let's say you are a careless driver, you accident, and then the whole traffic is jammed up because of your car. Are you liable to pay everybody because they waste their time 1 hour there waiting for you, because you block the road? Right, you will have to pay thousands or hundreds of motorists in the highway. So it's too it will be extensive, yes, and you don't know how much you'll be liable for. And also another reason is they want parties to put the terms in the contract. They don't want everybody to sue on the dot. So what is pure economic loss? Is if the manufacturer, example, sells a defective product, the product explodes. If you claim for a replacement product, it's pure economic loss. Right? If the explosion damage your property, let's say your house or the nearby property is damaged, you can claim. But if you say now you cannot work, right? Your factory cannot operate, you lose 1 day, you lose 1 week, you cannot do business. This is pure economic loss, right? Yeah. But if your factory burned down, right, and then you cannot generate profit, then it's not pure economic loss anymore, because it is economic loss consequent on property damage, right? But let's say if, for example, in the Spartan Steel case, the electricity, like the Naga National, they cut the electricity, and then this steel maker, he say he claimed for lost profit because let's say 1 day or 1 week he cannot produce steel. They say you cannot claim for production of steel because it's economic loss, pure economic loss. But whatever steel was in your furnace, and that steel became spoiled and your whole furnace is spoiled now, you can claim for your damaged furnace, because there is property damage. There is economic loss consequent on property damage, then can. Right. So normally cannot, except if you follow the Hadley-Bryan principles. Okay. So Caparo explains what Hadley-Bryan principles are. Is number 1, you must know the purpose of your advice. Right. This is for misstatement, because I'm focusing on misstatement. And the advisee is likely to act upon without independent inquiry, no disclaimer, and it's reasonable for the advisee to rely. But even this also is not guaranteed. Okay. So other countries is easier, like US very easy to sue one. Okay, like Germany, Canada, Australia is easier, but US is I think the easiest for pure economic loss. But Malaysia, sometimes they say, the judge say we might not want to be so strict as UK, right? So first you have to determine the scope of duty. You cannot just say there is no duty of care. You have to determine what is the scope, right? Because you have, sometimes you provide information, sometimes you provide advice, right? So for example, there's this Samco case. So the surveyor tell the bank the property is worth a lot of money, but actually the property is not worth so much. So when the bank loan the money, the bank, and then the borrower defaulted, the bank cannot recover lah. So what count, you are liable for the damage of, you know, between a prudent valuation and the valuation given. Okay, but later on the property dropped further, on the subsequently the property dropped even further. So you cannot claim for the subsequent drop in valuation. Okay, you have to claim up only, you are only liable for, the surveyor is only liable for up to here only, up to the difference between the prudent valuation and the valuation given. So another case, Lord Sumption, he used the term assumption of responsibility. So it means basically if it's done in a commercial setting, right, then normally people will rely on your on your misstatement, on your statements. So even when you are, even can extend to services also, right? And when you, so this is the, like, in the rule of Ends and Merton, they say that third parties can sue construction professionals, right? The government, there's a government body, they approve the building, but later on the building got defects, or is it collapse, or got defects or what, then the purchasers they want to sue the government. So the case in Ends and Merton say can, because it is foreseeable, right? You can foresee that if you don't do your job, somebody will suffer harm, so can. But later it's overruled by Murphy and Brentwood. They say you must use only contract. So the purchaser have to sue developer, developer only can sue the other parties. So because it is pure economic losses. Right. So for example, in the Malaysian Highland Towers case, they say there's for property, whether you consider property damage or economic loss, there's not much difference. So they say normally can, not so difficult. But if you want to sue the government, then they say no, it's not. Because why? They went to the federal court. Okay, he say the main reason, one of the main reasons he says, somebody will have to pay. It's not fair, not good policy to use taxpayers to compensate the victims of Highlands Tower case. Of course, this is not because people die. I think got 40 over people died in this case, right? The Highland Tower collapse. So we're not talking about the people who died. This one is more talking about the property that was damaged. Okay, so they want to sue the government. Of course, the engineers, the architects, all they were held liable. Okay. So when you have a breach, they consider what a reasonable man would do, right? So if you are a professional, you're a doctor, accountant, lawyer, then they will look at expert. So you got expert witness to come and testify. So it can cost a lot of money, okay, to get experts to testify what they would have done, each part. And and the Highlands Tower case, right, they say that even if your employer asks you to break the law, you cannot use that as a reason. You are still in breach of your duty. Okay, and you cannot say because your contract only say you look at one area, and then you don't look at the whole area. But actually you have to look at the whole site, because you are the architect. If you don't do your job, the whole building collapse, blame who? You have to blame the architect, right? Right, you cannot hide away from a limited scope of duty in your contract. And causation, we look at the factual causation, which is the but-for test. If it wasn't for what you did, then would the the result happen, and we look at the material contribution test. Did you increase the risk? How much you increase the risk of the thing happening? And the judges, they have said that it is a common sense. They use their common sense to decide whether it caused it or not. If you have many people who did the wrong thing and you don't know who was the one, everybody, all the person who breached their duty, who was negligent, will have to pay their percentage. Whoever contribute 10%, then you pay 10% of the damages. And the burden of proof is on the tortfeasors, okay, because sometimes cannot be proven by the claimant. You have remoteness. Remoteness means you don't have to see the degree of the damage. All you have to see is the kind of damage that will happen. Like if you, Tenaga Nasional, take out the electricity, cut the electricity, then you know a lot of factories, you know, a lot of people will suffer, right? So what kind of, even you don't know how much, maybe million, maybe billion, you don't know, but as long as you know the kind of damage, but later you will see it's not so easy to sue for pure economic loss, okay. If not, Tenaga, every time they got power cut or what, then they will have to compensate a lot of money, so it's not so, that's why pure economic loss, they want to say no you cannot breach of statutory duty. So if the powers of the entity comes from statute, then you have to follow the statute. The statute will say if they do something wrong, then what you should do. But if it doesn't provide any remedy, then the courts can decide on the case using common law. So accountants and auditors is just one example. So we have the contract will have an implied term right, and to use reasonable care and skill. So you can sue under contract if they didn't do their job. But if you don't have a contract with the auditors, let's say you are a third party, under this case, Kapoor and Dickman, auditors don't owe a duty to general public. But under this case, Smith and Eric, you can owe a duty, but it is a restricted class of persons. Okay, and it's reasonable to rely, and they are also reasonable to expect to be relied. So for example, if you have and the damage is only liable to they only owe the maximum they owe is to whatever shareholders, existing shares the shareholders hold, not to whatever new shares the shareholders buy, right? Because their duty is only to shareholders and so if let's say when the buyer, right, you have merger and acquisition, so the buyer wants to buy a company. If the auditor or accountant come and say this company doing very well, making X amount of profit every year, right, this kind of statement you can be an assumption of responsibility, okay. So you can owe a duty of care. If you let's say in a meeting you tell, let's say the auditor say no problem, this company doing this business, no problem, no legal problems or what, can. But then provided it is very specific and there's no disclaimer, okay. So remedies and damages. So tort damages is not so like contract very hard to claim for non-financial loss. Tort you can claim. Let's say you broke a leg, you have suffering, you painful, all this can claim one. But how to claim is not beyond this subject. Okay, how much to claim and all, you have to study the cases. Contributory negligence. So you don't want to be, if the claimant is negligent himself, then you will reduce the damages. Okay, but if it's deceitful, then of course no, you don't reduce. If let's say you are the auditor and you rely on audit confirmations, right? You send audit confirmation to lawyers, you send it to banks, you send it to debtors and creditors. If they were negligent in their audit confirmations, for example, the auditor after getting sued, he then will sue the other party lah to recover the money. Okay, but the claimant doesn't have to sue all the parties. You only need to sue the auditor only. Okay, for all the losses ah. So disclaimer, this one very important because in contracts, right, they will always want to say that they are not liable for negligence they're not liable for any losses suffered from their misstatements. So in UK they follow the Unfair Contract Terms Act. In Malaysia we only have Consumer Protection Act okay, so in UK it covers both commercial and consumers. Malaysia we mainly cover consumers only, right? So for example, the term cannot be all these are harsh oppressive all these they will say is unfair lah. So for example, if the buyer, the consumer doesn't know what he's signing, he doesn't know the product, he never read the contract, he got no bargaining power, he never negotiate properly, he got no legal advice, the terms the exclusion clauses are all in very small letter, who got time to read, all these things you will say is unfair. And then they cannot, if unfair, then they cannot rely lah. The defendant cannot rely on the disclaimer. So this is just an introduction so do you think the law of negligence, right, is satisfactory, right? Of course it's not so easy especially for medical negligence. Is very difficult because you have a lot of expert evidence. But in terms of auditor and accountant negligence, right, let's say if you are an accountant and you know your accounts is not accurate right, and somebody out there, let's say the government or the tax agent, the tax authorities or what, will rely on your accounts, and maybe the shareholders will rely on your accounts, right, because because a lot of people rely on audited accounts but the law says no because you don't know who they are you don't owe to everybody okay, maybe only to existing shareholders so if the existing shareholders, the shares from $10 becomes 0, now you only liable to pay them the $10 maximum right. That is if they prove that you was negligent so it's this one is up to you to conclude. I don't know enough to so-called criticize, to analyze all this, because I never really haven't even taken my exam yet, whereas year 1 I already passed my exam, year 2 I haven't passed my exam yet. Okay, I haven't even done any any questions, so I have no capability to do this, to answer this. But we can see negligence is very wide anybody can be negligent. The government can be negligent, prime minister can be negligent, the CEO, you, me, we drive car also, we can be negligent, right? Because negligence basically means carelessness, right? So the law must have a way to compensate victims. We don't want to, every time you are negligent, do you have to pay or not? When you cause harm to people, do you have to compensate them, or can you say sometimes the guy is too far away, you don't have to, like when I do this video, if I make a mistake, do I have to pay you for negligence or not? If I make a mistake, do I owe the whole world a duty, right? So we can see that there must be there must be a way so the law is developed in this way to say that they use duty of care to say there's no duty okay. So duty of care normally is the one that limits your claim. Okay, breach normally not so much in exam okay. So can we sue the government? So there are people who say they want to sue because you see the flood in Malaysia lately, it cost billions of dollars of damages of the flood, and it always happen frequently. So the government never do, I don't know whether they will do anything but people are not happy and then there are people like the Taman Sri Muda, few people died there, I think, then they want to sue the government, and some lawyers say you can sue the government, you can, but you look at the duty of care because if you say if it's pure economic loss, the government will say there's no general duty. Okay, the government cannot, and also they will say it's not good policy. Every time there's a flood, is the government liable for all economic losses that it suffered? The government will use this argument, so it's not so easy to succeed. And then they will say, many people will sue the government. Right? Everybody, the moment your house, your car get damaged, everybody will file a case in court. If you allow people to sue the government, and then they will say the government will be distracted. Instead of doing A, they will do B, and then they will be very defensive. Right? They will close down banks. They will they will do a lot of things just to protect themselves. They will use it as a defensive practice. And you can see the Highland Tower now. This two tower is they haven't demolished it yet. Up to now, it happened in 2000 or 2004 or something. The tower collapsed. One tower collapsed. Two towers is still standing. A lot of yeah. So and then you can see the Highland Tower is on top of a hill. You can see KL skyline from the. That's why it's on the slope. That's why it collapsed. Okay, you can read that more. Read more. So it's a fact. In life sometimes we don't purposely right do it, like we say this is act of God right, when the flood happens. But negligence also, yeah, it's hard it's hard for the law. Even if you say you can sue and it's negligent, how much do you want to compensate? Is it liable for all? So the law is not so straightforward like I say in the introduction. Okay, still developing. And yeah, this is the conclusion. Thank you. Bye.